5.
Ranjan Das.
Ranjan Das, yes.
He is the executive
Executive engineer, right.
Khobarhub.
Lordship, yes. Lordship kindly takes up page 4, paragraph 4.
We will suspend him now.
No, the
We
matter,
will suspend him now.
but the matter is being processed.
We will suspend him now for this affidavit.
Lordship,
Is he trying to hoodwink the court?
Two things, aspects seized from the inception. Unauthorized construction of additional 3 floors, that is 2.5, is proved and evident from the admission of the affidavit of the respondent 5 and 8. False FIR, bearing so had started against the petitioner, which would be evident from the CCTV footage and the report of tower location. My lord, then, that I submit, the petitioner submit, that if the above 2 allegations are proved false, I would be compelled to deposit cost of 50,000 only, which would be used for noble purpose of legal aid for wasting the precious time of the honorable court.
Now, this FIR 137 of 2024, what is the revision? I mean,
Well, stay on a hearing.
case number.
Case number 1-3. CRR.
TRR.
CRR 30. Well,
Where is the order? Stay order.
Just yes, 3044. 3044. 2024. Well, they did not. In spite of reported request, in spite of reported, I filed application. In spite of order, they did not file any report. How they will report? They cannot build a castle in a year, my lord.
CRR number?
CRR number 3044 2024.
3044
of 2024.
Date of the stay order?
Date. And when I filed a writ petition, that writ petition was assigned before your lordship, my lord. That Justice Ghosh told what I will do. Stay was granted. I told my justice that you have power, enough power under Article 266. I have filed this writ petition before your lordship, claiming 1 crore compensation to that so-called unholy police officers and from dismissal of service. That is also placed before your lordship, and your lordship assigned that matter to Justice Mrs. Hoffman.
Yes.
now, yes, Lordship, in compliance with the Lordship's direction, I have already filed an affidavit by stating that at the time of inspection, no new construction was made.
No. Let us see.
Yes, Lordship kindly takes up my affidavit.
That
Respondent number 5. Respondent number 5.
Ranjan Das.
Ranjan Das, yes.
He is the executive
engineer, right. Lordship, yes, Lordship kindly takes up page 4, paragraph 4.
We will suspend him now.
No, the matter.
We will suspend him now.
But the matter is being processed.
We will suspend him now for this affidavit.
Lordship.
Is he trying to hoodwink the court?
No, Lordship kindly sees.
No, please answer the question, Mr.
My lord.
Counsel. You are representing a statutory body.
My lord.
Okay. He is a paid employee of the corporation. He has got a date of retirement also. Right and now we will suspend him. Right and now we will suspend him for his irresponsible affidavit which he has filed before this court. It's a clear attempt to hoodwink the court. If he thinks he is above law, we will show him what is the law.
No, that is.
He is not going to go home today. He will go to the correctional home.
No, I'll
From the office, which he is in SN Banerjee Road, he will go to the correctional home, not to his home. You never file such affidavit. You are a counsel representing a statutory body. You have to vet the affidavit before it is filed. Here is a case, admitted case of G+2 approval granted, 3, 4, 5 unauthorized. So what you should do? You should have inspected it.
No, we have.
Only one at a time. Okay. You should have inspected it. 3, 4 and 5 floors cannot come within a day. It is a lane of 6 feet. Where did they dump the construction material? So your fellows, your inspectors, your junior engineers have connived with the private respondent in indirectly assisting him to put up this construction. Maybe it is a 100-year-old construction. You have no power of regularization. Even such power was there under various statutes framed by various state governments that have been struck down. Amnesty scheme was brought by various state governments that were all struck down. In one of the judgments, I think in this compilation it is there. It is called Consumer Action Group. Have you tried? Consumer Action Group. That matter arose from my home state, where 3 government orders were passed, where sanction was obtained for ground plus 3 floors and construction was made for ground plus 11 floors. Only once the Honorable Supreme Court granted a one-time exemption. The state government took advantage of that, and every 2 years they started issuing government orders saying that all right, he comes under an innocent builder category who has put up 12 floors. Therefore, you pay at the rate of so and so rupees per square feet as a regularization fee. We will regularize. All those government orders have been struck down. So therefore, what he should have done is he should have signed a plain affidavit saying that, sir, I went and inspected as per my office record. The approval is for G plus 2, but existing so many floors are there, and leave it at that. You have issued a notice under section 400. What is the penalty for 400? 300 rupees fine.
No. The
You
authority.
have not done anything. So therefore, can we not accept the submission of the petitioner's counsel?
No, my lord, I'll say.
That your engineers are colluding and conniving with the private respondent.
No, may I now make my submission? But
We are going to direct immediate action subject to what the private respondent will say.
we'll go.
You see, the thing is, cosmetic demolition.
No, that will not do. That will not.
Cosmetic
No,
demolition.
that will not do.
So your engineers don't think they can outsmart everybody.
No, but nowadays,
Probably they can outsmart you, not the court.
No, may I just say this? But on earlier occasion.
All right, senior has come. Mr. Ghosh has come. So when such an affidavit is brought to you,
My lord.
before it is vetted and signed, you should say no. You place facts, sir. Statutory authority should place facts. You can never support this man, assuming he has put up construction unauthorized. Take action against him.
Of course, my lord.
The entire lane. Take action against everybody. Why are you afraid? Court will protect you.
My lord. Well, I know, my lord, this bench, my lord, always protecting us.
Yes.
Earlier, but in many cases, the lordship also they get assisted.
This Ranjan Das affidavit is very.
Well, let me look into that, but I could not, my lord, go through the lordship and takes it up, and of course, my lord, the lordship, my lord, direction and whatever.
Today the matter is going to end. What is the private respondent stand?
First of all, my lord,
Very influential man, your client.
my lord, that person died. Person who,
But the nemesis will continue, sir.
my lord, the
Sir,
constitution
the
was-
person who illegally, inherited the estate, inherits not the estate. Along with the illegality, he inherits.
my lord, that is the widow of the earlier landlord. Private respondent number
We
10.
created a first case, my lord. Case
I-
of rape,
Yeah.
my lord.
Against your client. Widow of the original owner.
widow of the original landlord. Now, whatever construction was done was around 20 years ago. I do not have any knowledge about how the construction was made or whether it was made within the sanction plan or
No,
what
it
not.
is not. That's an
It's not, it
admitted
is not.
position.
If that's so, my lord, whatever citations my learned senior friend has cited, none arose from a public interest litigation. I am on a very simple point. My lord, kindly, if my lord, the petitioners, my lord, had filed an writ petition. My lord, WPA 15530 of 2024, same cause of action. They withdraw it, seeking liberty to file the same on a same fresh cause of action. Now, what they do, my lord, they do not approach that court. They come direct. This is court for filing a public interest litigation. Now, whatever citations that has been followed by, whatever that relied upon by the senior friend, arises from an orders that was passed not from a public interest litigation. All those citations, all those states, and they do not have a separate tribunal. Over here, my lord, the KMC tribunal has established. My lord, we have now the bench are operational. After my lord has passed orders, my lord, the judges have been appointed, the bench is now operational. My lord, good, bad, indifferent, let KMC pass a demolition order. Let us contents. There are around 50 families in that 5-storied building. He ought to have made them parties.
Who indicted them?
I don't know. My husband, my late husband. that is why I
Then
say-
walk out. You walk out. Ask your client to walk out.
I may walk out of the premises.
You walk
What
out.
about the 50
He will
others?
deal with that 50 families. KMC will deal, police will deal.
What about, but that is the only point I was thinking.
Sir, we can't do anything, even assuming you are questioning the bona fides of the writ petitioner. The court can always discharge the writ petitioner
Yes, my lord.
and entertain the matter. Here is a patent illegal. Assuming there is a fire accident. Admittedly, in a gully which is about 6 feet wide, nothing can go inside. Even an ambulance cannot go inside. At best, 2 or 3 two-wheelers can be taken inside. So in that, if you put up such a construction, whom are you putting in peril? Probably, all right, 53 families will get charged to death. The neighbors also will get charged to death. That's the problem, no? It is not your building alone. If your building tilts, your building catches fire, what about the neighbors? They are in a Tika land with a tiled property. That will be the first, they will be the first victim. You are in a concrete construction. Sir, you proceed.
Well, Your Lordship, all that I'm submitting to Your Lordship, I appreciate that these total construction is unauthorized. Persons are in occupation. Your Lordship directs the police to vacate from first to the top floor and the floor to floor. Then we may start the construction of the demolition of the structure with the assistance of the
3,
police.
4, 5.
My lord,
They will be evicted.
my lord.
They will be given an opportunity to vacate. If they don't vacate within a time frame, then the police will assist. Police will take action. Where is Mr. Who appears for the state? He was appearing online.
Additional solicitor, additional government pleader.
No, he appeared just now.
Session, Naki.
No. Yeah, Mullik.
Mr. Biswarup was appearing.
Mr. Biswarup Mullik.
He was in.
Where is he?
He was online, he was online. He is online.
Online দেখা যাচ্ছে না তো online.
He appeared. This public interest writ petition has been filed, highlighting a menace which is plaguing the larger part of Kolkata and several parts of the state of West Bengal, wherein illegal and unauthorized constructions have been put up, and the authorities have failed to take any action. At the very outset, we shall deal with the preliminary objection raised by the private respondent, the present owner of the building, with regard to the locus standi of the petitioner to file this writ petition. It is submitted by the learned advocate for the private respondent that the writ petitioner had earlier approached the learned single bench of this court by way of a writ petition for the self-same relief. Somebody called Mr. Biswarup Basu Malik.
Biswarup Mullik.
Self relief, which was withdrawn with liberty to file a fresh writ petition, but without approaching the concerned court, this public interest writ petition has been filed. In our considered view, this objection is wholly untenable, since the petitioner has not only exposed the cause, his cause, the petitioner has exposed the cause of all the people who are residing in that particular lane, which is stated to be only 6 feet in width. Therefore, we reject the preliminary objection raised by the learned counsel for the private respondent as regards the locus standi of the petitioner to maintain the writ petition. The next submission of the learned advocate for the private respondent is that if as and when the Kolkata Municipal Corporation within bracket KMC passes an order of demolition, it will be well open to the private respondent to approach the building tribunal, which has been constituted under the provisions of the Kolkata Municipal Corporation Act, and seek appropriate relief. Such submission cannot be accepted in the instant case, because the matter concerns the safety and security of all the people who are residing in the said area, which is a narrow lane measuring about 6 feet in width. Therefore, the private respondent who has admittedly put up illegal constructions with illegal construction of third, fourth, and fifth floor in the premises without obtaining any building plan approval has absolutely no ground to plead for any equity being exercised in their favor. If the private respondent pleads for equity to be exercised in their favor, the private respondent or her husband, who was the predecessor in title, should have acted in equity. And since it has not been done so, the question of the private respondent seeking umbrage under the various provisions of the Act in order to escape the rigor of law cannot be accepted. Therefore, such contention raised on behalf of the private respondent also stands rejected. A report in the form of an affidavit has been filed by the executive engineer within bracket B of Borough Roman 9, KMC, Mr. Ranjan Das, dated 7th November 2024. To say the least, the averments in the affidavit shows that the officer does not want to place full facts before this court. And we may be justified in accepting the stand of the petitioner that the officer is colluding with the private respondent and trying to protect and shield them from any action against the unauthorized construction. The affidavit filed by an officer working under a statutory body should be clear and unambiguous and state the exact factual position. Any other averment which may give a color to support a particular party should be fully avoided, should not find place in such affidavit. However, on going through paragraph 4 of the affidavit sworn to by Mr. Ranjan Das shows, gives a color as if the said authority is attempting to protect the private respondent who has admittedly private respondent's property, which is of which third, fourth, and fifth floor are unauthorized. Several judgments have been placed by the learned advocate appearing for the writ petitioner in support of his contention as to how the cases relating to unauthorized constructions have to be dealt with. We may refer to a few of the said decisions.
পুরো খিদিরপুর ফাঁকা হয়ে যাবে তো একবার পুরো মবিনপুর তো ফাঁকা হয়ে যাবে
The Honorable Supreme Court in Dr. G.N. Kajuria and others versus Delhi Development Authority and others, 1995 5 SEC 762, pointed out that the authority concerned misused the power and allotted the plot earmarked for a park for a nursery school, which was condemned, and the order for cancellation of the allotment, besides recommending penal action against the authority concerned, was made. In MI Builders Private Limited versus Radhesham Sahu, 1999 6 SEC 464, the Honorable Supreme Court in clear terms held that there is no alternative to the construction which is unauthorized and illegal to be dismantled. In Isha Ekta Apartment Cooperative Housing Society versus Municipal Corporation of Mumbai, 2013 5 SEC 2013 3 SCC within bracket civil 89, the Honorable Supreme Court observed that the courts are expected to refrain from exercising equitable jurisdiction for regularization of illegal and unauthorized construction. In Supertech Limited versus Emerald Court Owner Resident Welfare Association others, 2021 10 SCC page 1, the Honorable Supreme Court held that illegal constructions have to be dealt with strictly to ensure compliance with the rule of law. In Kerala State Coastal Zone Management Authority versus Maradu Municipality, 2021 16 SCC 822, the Honorable Supreme Court reiterated that illegal and unauthorized constructions put up with brazen immunity, BRAZE, cannot be permitted to remain. In State of Haryana versus Satpal, 2023 6 SCC 643, the Honorable Supreme Court held that the High Court committed a very serious error in directing to legalize the unauthorized occupation and possession made by the original writ petitioners on payment of market price, and the same was quashed.